Good morning, Gary DeWaal here, and this is Bridging the Week for June 23rd to 27th, and today is June 30th, 2014, and the beginning of a shortened work week in the U.S. because of the July 4th weekend coming up. Last week, the Securities and Exchange Commission issued its first rules governing cross-border transactions involving security-based swaps. Overall, these rules are parallel to guidance previously adopted by the Commodity Futures Trading Commission, but different in some material respects. Also, last week, the Financial Industry Regulatory Authority issued a red flag to a broker-dealer and its CEO for engaging in fraud against many current and former U.S. professional football and basketball players. Talk about unsportsmanlike activity. The Securities and Exchange Commission last week adopted its first in a series of rules aimed at cross-border security-based swap transaction. These first rules establish when a cross-border transaction must be counted to determine if a non-U.S. person has to register as a security-based swap dealer or a major security-based swap participant, as well as the scope of the agency's anti-fraud authority. The SEC also adopted a final rule establishing the procedure for submitting substituted compliance requests, pursuant to which, if granted, a non-U.S. security-based swap dealer or security-based major swap participant can rely on certain of its home jurisdiction's rule to satisfy comparable SEC obligations. The actual nature of substituted compliance will be addressed in a future SEC rulemaking. In the U.S., security-based swaps are swaps based on a single entity's security or a narrow-based security index. Jurisdiction over swaps and certain persons engaging in swaps activity, except for security-based swaps, lies in the U.S. with the Commodity Futures Trading Commission. Jurisdiction over security-based swaps and persons engaged in certain security-based swaps activity resides with the SEC. The CFTC and SEC share jurisdiction over certain mixed swaps. I know this sounds a bit confusing to those of you outside the U.S., but take assurance it's also confusing for those of us in the U.S. Previously, the CFTC issued interpretive guidance and an exemptive order to govern cross-border swaps transactions. A lawsuit is pending against the CFTC for its issuance of its requirements as guidance as opposed to rules. Under the SEC's new rules, for purposes of assessing its obligation to register as a security-based swap dealer, a non-U.S. person must count towards a de minimis threshold all security-based swap transactions with counterparties that are U.S. persons, including foreign branches or offices of U.S. banks, that are not registered as security-based swap dealers, have rights of recourse against a U.S. person affiliate for a non-U.S. person's obligations under a security-based swap transaction, and are so-called conduit affiliates, for example, where through internal group transactions, the risks and benefits of a security-based swap with a non-U.S. person are transferred to a U.S. person. These requirements are parallel but different than CFTC requirements in some respects. Likewise, the definition of U.S. person by the SEC differs from the comparable definition by the CFTC. For the SEC, a U.S. person includes natural persons who reside in the U.S., any legal entity or vehicle that is established under U.S. laws or has its principal place of business in the U.S., any discretionary or non-discretionary account of a U.S. person, and any estate of a decedent or decedent that was a U.S. person at the time of death. The SEC's final rules define place of business as, quote, the location from which the officers, partners, or managers of the legal person primarily direct, control, and coordinate the activities of the legal person, end of quote. In commentary regarding its new rules, the SEC said it will later solicit comment on how it should address security-based swap transactions between two non-U.S. persons when activity related to such swaps occurs at least partially in the U.S. Finally, the SEC's final rule states that its anti-fraud authority is applicable wherever there is sufficient conduct in furtherance of alleged fraud or sufficient effects of the alleged fraud within the U.S. The effective date of the SEC's new rules will be 60 days after they are published in the Federal Register. Stay tuned. Barclays Capital Inc. and Barclays PLC both were charged last week with violations of New York State law regarding the bank's operation of its dark pool known as Barclays LX. The New York State Attorney General alleged that Barclays may not have been fully forthcoming with its institutional investors regarding the activity of high-frequency traders in its dark pool. According to a Barclays press statement published on its website, quote, "We take these allegations very seriously. Barclays has been cooperating with the New York Attorney General and the SEC and has been examining this matter internally," end of quote. In a separate but related development aimed at enhancing market structure, the SEC instructed national securities exchanges in the U.S. and the Financial Industry Regulatory Authority to develop and implement a 12-month pilot program to widen tick sizes for certain small capitalization stocks and to assess how this impacts market quality for U.S. investors, issuers, and other market participants. An SEC-registered broker-dealer and its chief executive officer were barred from the business in order to make restitution to 59 investors, the majority of whom were unnamed current and former professional U.S. football and basketball players. By the way, in the U.S. football is not the round ball, it's the longish ball. This was as a result of the Financial Industry Regulatory Authority hearing panel finding that the broker-dealer, Success Trade Securities Inc., and its CEO and founder, Fuad Ahmed, engaged in a fraudulent sale of promissory notes and marketed a Ponzi scheme. Talk about red flags. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the Gary DeWaal and Associates website. Among articles covered are one regarding the extension of certain deadlines previously granted by 2 CFTC no-action letters and one discussing new amended question and answers from ESMA regarding trade repository reporting. Check them out. In any case, until next week, this is Gary DeWaal. Have a great week, and for those in the U.S., enjoy your upcoming 3-day holidays. Ciao!